Today I want to talk about a case that just came down from the Michigan Supreme Court in June, a case called Woodman versus Cara LLC, or as I like to call it, the Bounce Party case. This is a case that anyone in a school district or anyone who has kids can easily envision. Bounce Party is a business run by Cara LLC, and Bounce Party is a facility that has bounce houses and slides and other inflatable toys and games. As part of their business plan, they have a waiver that parents have to sign for their kids to be able to play in Bounce Party. Well, the Woodman family rented the Bounce Party for their son's 5th birthday party. And as you may be able to imagine, their son at one point jumps off of a slide, falls, and breaks his leg. So the mother, on behalf of the son, brings a lawsuit suing Bounce Party for the damages that resulted from the breaking of the leg. And Bounce Party, of course, replies and says, no, these claims are barred because of the waiver signed by the father. And the family brought 3 different claims: a negligence claim, a gross negligence claim, and a statutory claim. And the trial court initially says, okay, well, we think the negligence claim is barred by that waiver, but the other 2 claims we're going to let stand. So both parties then appeal to the Court of Appeals. Court of Appeals, of course, Bounce Party claims that all of them should have been barred by the waiver, and the family says none of them should have been barred by the waiver. Court of Appeals agrees with the family and says that a parent is unable to, under the common law, is unable to waive the pre-injury rights of their minor child. Bounce Party appeals, and the Supreme Court agrees. In a lengthy opinion written by a few different justices, they decide that the common law in Michigan, and really in other states as well, is very clear that a parent is unable to waive the rights of their minor child in a pre-injury waiver. Which, of course, for the business creates some complications because a minor child can't be bound in contract either. So the kid can't waive their pre-injury rights, and the parent can't either. The court also makes an interesting point in the discussion as well, in that the original waiver in this case seemed to require that rather than waiving the rights of the child, that the parent would be required to indemnify Bounce Party of any damages that may occur from a lawsuit if one is brought. So in other words, if someone brings a lawsuit because of the injury, the parent who signed the waiver would be responsible for the costs associated with that lawsuit. But the court said that the Bounce Party never actually argued that, and so because they didn't argue it, they couldn't really make a holding on it. But the court did imply, or at least one justice specifically did, saying that an indemnity provision like that would be viable and enforceable. But since it wasn't argued by the parties, that argument was lost. So the holding comes out and it says, again, that parents can't waive the pre-injury rights of their child. So when this is learned by school districts, the first question is usually, well, what does that mean for us? Should we even bother with these waivers anymore? And we at Luskin Albertson think that, yeah, you still should. For a couple of reasons. One, the Supreme Court made a very significant point in their opinion in that the common law bars these waivers, but that doesn't mean that the legislature can't change that. And they made the point of saying that the legislature is in the position to be able to change that common law where they, the court, were not. And that if the legislature believes that these waivers are a valuable thing and should be allowed by businesses, then they can make a law to enforce them. So as a school district, if you have one of these waivers in place and a law comes along and changes and allows these waivers to be enforceable, then that waiver that you already have will stand. So we think there is still value in that. Not to mention the fact that a court can always reverse itself. It's happened before, whether it would be a continuation of this case or in a new case. Also, we recommend that any of these waivers have an indemnity provision. Because of the language of the court seemed clear that one of these indemnity provisions would be enforceable. we think it's a valuable asset for a school district to make sure that if they are going to be taking these risks, that they have an indemnity provision in their waivers. So if there are any questions about this, or if you have any provisions that you want to look at, or if you have one that you need drafted, please don't hesitate to give us a call here at Luskin Albertson, and we can get that done for you.